All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Thomas P. Weidner, Judge, is presiding. All persons having business before the court, draw near, give attention, and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning and welcome to this session of oral argument of the 5th District Court of Appeal. Let me introduce the panel to you. I'm Judge Sawaya. To my right is Judge Lambert, and we're pleased to have Judge Kelly McKibben from the 18th Judicial Circuit, who is a circuit judge, sitting with us by designation as an associate judge of the court. We are very pleased to have her with us today. We have 3 cases on the docket. They are all civil cases. Each side will be allotted 20 minutes. The appellant will be entitled to reserve some time for rebuttal if the appellant will have an opportunity for rebuttal. Let me know. We have a clock on the podium, and if the appellant wishes to reserve any time, just let me know. If you have any cell phones or electronic devices, please turn them off so that we're not interrupted during the course of the oral argument. So with that, we'll take the cases as presented on the docket. Florida Peninsula versus Kelly Mullen Plumbing.
Ken Mullen.
Good morning. I'm Hinda Klein here on behalf of Florida Peninsula, and I'd like to reserve 5 minutes for rebuttal.
Okay.
The case before the court is fairly simple and procedural, and that is whether the trial court erred in dismissing Florida Peninsula's subrogation, indemnity, and negligence claims against a potential third party, in this case Ken Mullen Plumbing, who had done plumbing work for the plaintiffs in this case.
As to the equitable subrogation claim, in essence, the resolution of that aspect of the appeal depends upon whether we follow we agree with the second and the fourth, or we agree with the third.
Correct.
And
yeah,
that's in essence it, because if we go with the second and fourth, it's pled correctly. If we go with the third, you don't dispute that the payment has not been made.
That's correct.
Okay.
Yes. And clearly, we believe that the Second and Fourth District Courts of Appeal are absolutely correct in finding that there is no material difference between an equitable subrogation claim and a contribution or indemnity claim, both of which are permitted to be brought at the same time as a third-party complaint. In this case, the only argument that was made by Ken Mullen Plumbing that the case was premature was essentially that of the Third District Court of Appeal, which is essentially said that a subrogation claim doesn't arise until such time as payment has been made. But as the Fourth District clearly said and persuasively said in the Gortz case, there's no difference between that kind of a claim and a contribution and indemnity claim, both of which are obviously contingent on the underlying claim being concluded. And given that, especially in contractual subrogation claims, that statute of limitations begins to run at the time that the actual loss begins to occur, there's really no distinction with a difference between a subrogation and indemnity and contribution claim. And in fact, it makes all the more sense that a subrogation claim should be brought and can be brought as a third-party claim at the same time as the underlying claim.
The common law indemnity claim, I mean, in essence, you alleged on behalf of your client that basically, A, we're not at fault, B, they're at fault, and C, we're only liable because of some vicarious, constructive, derivative, or technical liability, and then the lack of an allegation of special relationship was apparently what the dispositive issue, even though we don't actually have a transcript of the hearing, but just based on what was filed and what the briefs are. And in essence, your position is under Houdale, and I guess the diplomat case from the 4th DCA is those three allegations are sufficient, that a special relationship is really just a description of vicarious technical derivative or constructive liability.
Yes, yes, that's what we believe that the Diplomat Properties case had held, but in any event, as we argued in our brief, really that's an issue that should be addressed outside of a dismissal, but maybe a summary judgment, if in fact the opposing party believes that there is no evidence that Florida Peninsula could be liable without its fault and has no direct relationship with
But
it.
their argument, Mullen's argument is you have to also allege that there exists a quote-unquote special relationship
Right.
in addition to those other three elements that I just outlined, and they interpret that from Houdale, although Houdale says basically common law liability, what we're really talking about is fault or no fault.
Correct,
So-
correct, yes.
So
And I
in
think
essence, the issue we have here is, are those two words, special relationship, critical in pleading a common law indemnity claim in Florida?
Well, I certainly think that they could be, arguably, but I believe at the end of the day, the ultimate decision of the trial court was that all of it was premature, including a common law indemnity claim, because no payment had been made yet.
But there's nothing that we could look at, I mean, the order doesn't say anything.
Correct.
Other than deny,
That's true.
dismiss with prejudice, dismiss without leave to amend.
And that actually gets to the final point, and I think the key point in here as to the remaining counts, and that is that the trial court clearly abuses discretion in not even permitting Florida Peninsula a single opportunity to amend. If the court believed that the requisite special relationship hadn't been pled with particularity or pled according to the case law, it certainly should have given us leave to amend, and this court, in the Carr versus Esslinger case, has basically said the failure to even give one opportunity is an abuse of discretion, and we would submit that that is
I
the
mean, the
case.
trial court doesn't really have discretion to deny an initial leave to amend under Boca-Berger, Florida Supreme Court case, Boca-Berger versus Forum. In other words, if you dismiss if I am filing a complaint, it's my initial complaint, the other side moves to dismiss it, the judge doesn't have the discretion to say, okay, I dismiss it with prejudice, I will not give you leave to amend, if it's your original complaint.
If there is evidence of record, and there isn't in this case, that there has been a showing of one of those three requirements, and in this case, I believe opposing counsel had argued that amendment would be futile. So they didn't...
Isn't that as to a second or amended complaint? I mean, isn't it as a matter, I mean, when there's a motion to dismiss, there's been no pleading from the opposing party, and you, as a matter of right, can amend a complaint before initial
Well, we didn't...
pleading isn't that accurate? I'm kind of on your side on this. You seem to not want to be on my side on this one.
I understand. I understand.
That seems to be that if you file a motion to dismiss, that's not a pleading. No different than if I file a complaint, I look at my complaint after 5 days, say, I think I'm going to amend it. I don't have to get leave to amend. I can just file an amended complaint, and then the defendant or the other side can respond to the amended complaint.
I'm sorry, I didn't understand your Honor's question in the first place. You're absolutely correct. A motion to dismiss is not a pleading, so theoretically, under the rules of civil procedure, we could have amended, but the trial court found that the amendment would be futile, and found that...
I'm taking that's based upon your recollection of the conversation, because there's not really the judge didn't say that in his order, and we don't have a transcript of the hearing as to why the judge did
That's correct, but
whatever he did.
that was the basis for opposing counsel's motion to dismiss the amended complaint. And I made the leap in assuming that that is why the court had granted the dismissal with prejudice as opposed to with leave to amend. So that's why I made that assumption. But I think at the end of the day, the bigger issue here is whether or not this court is going to adopt the second and fourth district's ruling with respect to the prematurity of a third-party complaint for any of these causes of action, or whether it's going to adopt the third district's rationale. And The third district really didn't have much of a rationale other than to argue or to hold that a subrogation claim doesn't begin to accrue until payment has been made, and as the fourth district really discussed in great detail and very persuasively in the Gortz case, that is a distinction with a difference, and one that doesn't carry the day, where ultimately you should be able to address all of the issues that arise from a single set of facts, which is the same facts here. There's really no good argument that this claim for indemnity or subrogation doesn't arise out of the same set of facts and circumstances. And therefore, we believe that the court should agree with the second and the fourth district and find that a third-party claim in this situation is not premature, and reverse it with directions on remand to permit the litigation of that claim. Thank you.
Okay.
Good morning, may it please the court. My name is Emily Matheson here on behalf of Appellate Mullen Plumbing.
Let me ask, what is your most persuasive reason regarding the equitable subrogation to require judgment and payment first before you can bring a claim like that? Give me your most persuasive rationale.
I would point to this court's discussion in the Hewitt and Sullivan cases, wherein there was a discussion of whether or not allowing the equitable subrogation claim to proceed in conjunction with an underlying claim would promote judicial economy. Some factors this court considered in the Hewitt case is whether allowing the equitable subrogation claim to proceed would interject unrelated issues into the underlying case. In this case, the plaintiffs have sued Florida Peninsula for breach of contract. That's a first-party situation involving application of an insurance policy.
So you're saying that your strongest reason is that you think that it would inject issues that shouldn't be injected into the case concerning the other counts or causes of action?
Yes, that's one reason. In addition, Your Honor, the plaintiff in the underlying case chose only to sue Florida Peninsula. They did potentially have a cause of action against Mullen Plumbing, chose not to sue Mullen Plumbing, and that was another factor in Hewitt that was discussed in pointing against judicial economy.
Don't the federal courts allow subrogation claims to be pled before judgment and payment? I mean, they allow that, don't they? You don't know?
I'm not entirely sure, as I see.
The next question was going to be, if the federal courts do it and their rules of civil procedure are similar to ours, why shouldn't we do it? What is your next strongest reason?
I believe the next strongest reason would be the fact that the plaintiffs did only sue Florida Peninsula, not Mullen as well. In the Sullivan case, which Hewitt discussed at length, this court had a case where the plaintiff had sued both the defendant as well as the third-party defendant. The cases were consolidated for purposes of discovery, but not for purposes of trial. And this court declined to allow the third-party defendant, the defendant to bring a third-party action for equitable subrogation and have it all heard at one time on the basis of judicial economy, even though the plaintiff had sued both parties.
Well, couldn't the trial judge, in response to Judge Savoya's scenarios or what your scenario, couldn't the trial judge in his or her discretion just sever the third-party action at some point if he or she thought it was becoming unwieldy or unfairly prejudicing the plaintiff in the main action?
I believe that
1.180 and that.
I believe that would be a potential remedy, but it was also in the court's discretion to not allow the claim to proceed, and the trial court denied it without leave to amend, but did not dismiss with prejudice, with the understanding that it could be brought in the future, because a large part of the equitable subrogation claim depends on the outcome of the underlying case. Also,
why should they then file the identical suit down the road as opposed to they have it now pending in this action, and if the judge chooses to sever, just sever it and let it sit and see what happens to the main action?
I think it would just be a matter of preference, but also in this case,
Preferences of who?
preference of the trial judge, also what makes more sense. We're fairly early along, I understand, in the underlying case, although it's been pending for some time. There's been limited discovery, not a lot of depositions taken, not even set for trial yet. There was also a concern with Mullen Plumbing being obligated to expend attorney's fees and costs and following along the underlying case, when in fact their end result might not be an action for equitable subrogation at all. And that wouldn't exactly promote judicial economy in that sense either.
Well, when you say it's not promoting judicial economy, it sounds like you're saying it's not economical for your client. It actually kind of seems to promote judicial economy by getting all the parties together in the context of a mediation or negotiation, et cetera, because their position is, we may end up paying because we have a contract of insurance, but we're really not the quote-unquote cause of the problem. And I'm not saying that anybody can prove that Ken Mullen is the cause, but that's past the stage we're at right now, though, isn't it?
I understand Your Honor's point there. I would point out that the attorney, the court, I believe it was the second DCA in the attorney's title versus Punta Gorda case, specifically indicated potential problems with allowing the third-party claim to proceed, and one of those was forcing litigants to incur unnecessary attorney's fees.
A defendant could implead a third party under the rules of civil procedure. What would be the difference in allowing a subrogation claim and allowing a defendant to implead a third party?
I think it would depend on the type of action in which the defendant was seeking to implead.
One of the reasons I think the second district gave for not agreeing with the decision of the third. The defendant could implead a third party. So what's the difference?
I think it would just depend on the type of action the defendant was seeking to implead the third party on. In this case, there's clearly no cause of action for common law indemnity or negligence. That would just leave the equitable subrogation claim, which was asserted.
Well, why is there no cause of action for common law indemnity?
In this case, there is no special relationship, or I would even go so far as to say relationship, between Florida Peninsula and Mullen Plumbing.
Well, Houdale suggests the issue on common law indemnity is fault versus no fault, and FPIC is saying we are not at fault. Obviously, we didn't do the plumbing work and we didn't cause the damage. We just have a contract of insurance. And if Houdale says the focus is fault or no fault, not what labels you use, and the fourth DCA diplomat says, that language, vicarious, technical, derivative, constructive liability, is really just a description of what a special relationship is that evolved as a matter of the facts, then it is a claim, it is a common law indemnity claim, isn't it?
Well, in this case, the underlying case is asserting contractual liability. It's a breach of contract case. The plaintiffs are seeking to hold Florida Peninsula liable for breach of contract. That has nothing to do with any sort of alleged fault of Mullen Plumbing. In the Diplomat Properties case, unlike in the instant case, there were actual ultimate facts alleged. Specifically, there was a relationship established between the owner of a property who contracted out with someone to install showers, who then contracted out with someone to manufacture the showers. So there was a natural relationship between the owner and then the manufacturer of the showers by which liability flowed. We don't have any ultimate facts in the instant case to support such a special relationship at all.
Are you saying there's no common law indemnity claim because the underlying claim, the main action, is based upon a breach of contract? Is that your understanding? Is that what you're arguing? Maybe I misheard you.
That's one, I think, factor in the argument, but the way I understand it and the way this court has, I believe, always required a heightened pleading standard in common law indemnification, specifically in the Horowitz case, is that there has to be ultimate facts alleged which give credence to the idea that Florida Peninsula is only obligated to pay the plaintiffs because of some sort of vicarious, technical, derivative, or constructive liability on the part of Mullen Plumbing.
Well, didn't we say in the Florida Farm Bureau versus Insurance Company North America that to plead a common law indemnity claim, you have to allege three elements? One, the plaintiff, in essence, is wholly without fault. The other party is at fault, and that the plaintiff is liable to the injured person only because they're vicariously, constructive, derivatively, or technically liable for the wrongful acts of, in essence, the defendant. If you plead those three, Florida Farm Bureau, Gate Lands Company versus Old Ponte Vedra Beach. It's a 5th DCA 1998 case. I mean, isn't that what they pled, FPIC pled here?
I believe they very pled the technical bare bones elements. However, I would submit that all the cases that Your Honor just referenced presuppose the existence of a special relationship. In those cases, there would have been ultimate facts.
What's the significance of a quote-unquote special relationship? If Houdale, which is the genesis of this, basically says we look at fault versus no fault, and the third-party plaintiff here says we're not at fault, third-party defendant, you're at fault, and guess what? Because of your fault, we are going to be liable to somebody else, so we would like to have it a pass-through, and you reimburse us when we handle that. You know, I don't think it's a valid argument to say, well, because the injured plaintiff, the homeowner chose not to sue you, that somehow is a factor in the analysis as to whether a common law indemnity claim lies.
But I believe, Your Honor, that there has to be some sort of ultimate facts supporting the flow-through of liability Your Honor just referenced. Specifically,
And that's an evidentiary issue as opposed to a pleading issue, isn't it?
I believe that this court, pointing into Horowitz, did specifically uphold the trial court's dismissal of a common law indemnification count on the basis that the party seeking indemnity did not plead ultimate facts supporting the finding of a special relationship. I would also...
But do you agree that the fourth DCA case in the Diplomat Properties versus Technoglass a couple of years ago, in essence says this is really what special relationship means. It just is another term for making describing a relationship which makes a faultless party only vicariously, constructively, derivatively, or technically liable for the wrongful acts of the party at fault. I mean, Diplomat basically says, look, if you caused it, and I'm bringing a suit, I'm not at fault, so it's not a contributory, a contribution claim, that's sufficient under a common law indemnity claim, and then the evidence will bear out whatever the evidence bears out.
I would agree that that's the technical holding, but I do believe that Diplomat Properties can be distinguished from the instant case because in Diplomat Properties there were clear allegations of a relationship. The term special relationship might not have been used, but I would submit it's just a technicality. In the instant case, I do believe that it's not proper for Florida Peninsula to plead it's not at fault when in fact its obligations are arising out of the policy of insurance with the plaintiffs and not out of any relationship with Mullen Plumbing. It's a separate inquiry. There can be no vicarious liability for any action of Mullen Plumbing back to Florida Peninsula. It doesn't flow through. There's no independent relationship.
Derivatively liable, if you don't want to use vicarious because that has some kind of connotation in the area of negligence law, they're derivatively liable that, their liability derives from the actions of Ken Mullen in allegedly negligently installing the plumbing, et cetera.
I would submit that Florida Peninsula's liability is direct in that it failed to honor the obligations of its policy to the underlying plaintiffs.
But if it ends up, well, I mean, I don't think it's an all or nothing. They have a right to have defenses to the insurance contract action being brought against it, but if at the end of the day they are liable to pay under the contract because this is a covered claim due to the actions of Ken Mullen, why wouldn't they have the right then to bring an indemnity claim and say, we paid, they contracted with insurance with us, we paid it, but we only had to pay it because of what you did, and we would like you all to reimburse us now.
I would think that would just be the equitable subrogation claim that could be brought after
Why can't they bring different causes of action? I mean, I understand there's a lot of similarity between the two, but we don't require a party to say, you bring in two causes of action, they smell alike, you got to pick one and go with it.
I would just submit again that it's the special relationship. There is no relationship between Ken Mullen and Florida Peninsula.
What is your definition of special relationship? How do you define that?
I would point to, I would say that a special relationship is one in which Florida Peninsula is only obligated to pay the plaintiffs because of some derivative, technical, constructive, or vicarious liability via an act or omission of Ken Mullen Plumbing, and I believe that's completely lacking in this situation.
But it's deriving from the omissions of Ken Mullen. I mean, you seem to be saying if there's a contract between the party seeking indemnity and the injured plaintiff, that as a matter of law forecloses the insurance company in this case from pursuing an indemnity claim, and I don't believe that's the status of the law, nor have I seen any case law that you cited in your brief that supports that.
Maybe I'm focusing too much on that. I just think it's a separate inquiry, and that there's no action of Ken Mullen that's specifically been alleged, some vague allegations of installing supply line that somehow affect the plaintiff's liability under a breach of contract suit. because those obligations flow from the policy and not from any action of Ken Mullen.
Then I guess, tell me if I'm misinterpreting what you're saying, then if it's not sufficiently pleaded in the instant complaint or third-party complaint, then I guess the judge should give FPIC leave to more fully flesh out whatever the facts, as you're talking about, that would support the claim, but not as a matter of law, just say it is barred, it is with prejudice dismissed because there does not exist a quote-unquote special relationship, which I struggle with, I think following up Judge Saway's question, give me a description of what a quote special, who's in a special relationship with who? Taking it outside of this case, give me a hypothetical of a quote-unquote special relationship.
I would point to the court's decision in the Dole's case. In that case, the owner of a boat was seeking to have the manufacturer of a product held liable. The court found that because there was a special relationship and that the owner of the boat was strictly liable under admiralty law, and the court traced the relationship owner to manufacturer of the alleged defective part and allowed the common law indemnification claim to proceed in that case. That would be a relationship.
Is there a special relationship between the insured and Ken Mullen?
I do believe there could potentially be a special relationship in that case, but it would be also more direct, and they would absolutely have, the plaintiffs would have standing to...
I mean, you're not sure that there's even a special relationship between the insured in this case and Ken Mullen?
No, there would be, Your Honor. I would think that.
Is there such a thing as that the insurer stands in the shoes of the insured when they're on the hook for paying the loss, so that they can go against the tortfeasor or the negligent party to recover their loss?
I do believe that the insurer only steps into the shoes once it has actually made payments to the insured, and we do not have that in this case.
They would step in the shoes only if they make payment?
Absent some specific policy provision, which we don't have in the instant case, or a specific assignment of rights of the cause of action for negligence against Ken Mullen Plumbing or even common law indemnity.
That's what I was going to say. That seems to be a turn from your argument. So in other words, if a payment was already made, if we were not having this discussion about the equitable subrogation claim, if FPIC had already paid the claim and then got an assignment of rights from its insureds, they're Smiths, I guess, FPIC would then be entitled to bring whatever causes of action against Ken Mullen as under the stepping in the shoes, including a common law indemnity claim, wouldn't they?
Provided, it would depend on how they pled the common law indemnification claim, and also I think if they could establish...
What would they, but the Smiths, I assign whatever causes of action you want, you've given me my money, I don't care what you call it, I'm out of here, you sue Ken Mullen, good luck, here's my assignment. And so Ken Mullen gets sued for common law indemnity by FPIC. Where's the special relationship that you seem to be saying that there now might be a special relationship because the insured has assigned their cause of action to FPIC, but I don't know.
I mean, I do think in that case, if there was a valid assignment specifically with all the language Your Honor
It's a valid assignment.
I do believe that would be a different situation than we have in the instant case.
So that became a special relationship when there was an assignment?
If the plaintiffs, which do have a relationship with Ken Mullen, did assign, there would be a special relationship. It would depend on the specific allegations of the common law indemnification.
So in essence then, if your opposing counsel runs out today and says, let's just clean this up, just go pay these people and we'll turn around and bring the suit, then there is a valid cause of action for common law indemnity, equitable subrogation, or whatever, assuming the assignment's broad-based. I assume every cause of action I may ever have.
I mean, potentially it could be duplicative if they've already made payments. I don't know what they'd specifically allege against Ken Mullen Plumbing other than we've stepped into the shoes, we paid, now you owe us the money.
I thought the issue in the equitable subrogation is there was no payment, so it was premature. I'm saying if they go pay it today, then they would have a cause of action for whatever claim they believe they could make, including, I guess, unless you're telling me differently, common law indemnity.
No, I think that would be correct, and the trial court didn't foreclose the possibility that they would ultimately end up paying the
But they
plaintiffs.
dismissed the common law indemnity claim with prejudice.
On the basis that the trial court adopted the heightened standard of the special relationship requirements, found that it was not pled and could not be pled as a matter of law, and there was thus the dismissal with prejudice.
Well, how about the other argument that the opposing counsel made at the end, that you can't just dismiss the first complaint with leave to amend without giving the opposing side, without giving them at least a chance to file an amended complaint, because under the civil procedure rules, you as a matter of right can amend your pleading once before the other side has filed a responsive pleading, which a motion to dismiss is not.
In response to that, I would submit to the court that the Florida Peninsula had never specifically argued amendment as a matter of right to the trial court in the motion for rehearing or in the brief. And also in this situation, the motion to dismiss hearing was essentially over when the Orr-Tennis motion for leave to amend was made. So I'm not sure it's technically in line with.
Well, but I mean, the judge dismissed the order, because we don't have the transcript of the hearing. The judge says, okay, your initial complaint had 3 counts. 2 are dismissed with prejudice. The other one's dismissed without prejudice, but without leave to amend. You could file it in some other case, I guess, if and when, in that judge's mind, the issue is ripe. How is that not erroneous just on those facts, that as a matter of right, they have the opportunity to file an amended complaint as the rules permit? And the Supreme Court seems to say, and our court recently, in a case called Unruh versus somebody, and I should know it since I wrote it, said that.
I see my time's expired. May I have leave to briefly answer your question?
Yes, go ahead.
I would just.
Judge Swoy is okay.
I would just submit that argument specifically just articulated by Your Honor was never raised, so I would submit that it was potentially waived.
It was raised in the brief, though, wasn't it?
Not specifically amendment as a matter of right. It was amendment unless there was prejudice, the amendment to privilege had been abused, or futility. So the focus is on futility, and that was the trial court's focus as well, and specifically in denying the motion for rehearing with regard to the Orr-Tennis motion.
Okay. Thank you very much.
Very briefly, I did want to address opposing counsel's argument that because the underlying claim is for breach of contract, there would be no right of common law indemnity. I think as this court has recognized in the Diplomat case, which is not out of this court, but in the Diplomat case out of the 4th District, it clearly says, contrary to Technoglass's argument, a party's liability for breach of contract can form the basis for an indemnification claim against a third party. So the argument that because one claim is for contract and one claim is for indemnity, the cases are unrelated, just doesn't make sense, especially in light of the fact that the allegations in the third-party complaint, coupled with the affirmative defenses raised to the Smith case, demonstrate clearly that the cases are obviously interrelated. Among the affirmative defenses that were raised by Florida Peninsula is Ken Mullen Plumbing negligent work in the refrigerator and water supply lines, and a number of other affirmative defenses having to do with wear and tear and deterioration, etc., all of which are going to involve the question of what was the cause of this leak. In the third-party complaint, Florida Peninsula very clearly alleged the negligent installation of water supply lines, etc., as at least part, if not all, of the cause of the leak. So these are not cases that are wholly independent, as in the Hewitt and INA cases addressed by this court, both of which I believe involved Stewart versus Hertz issues, where one case involved malpractice and one case involved an accident. The court also asked whether or not the federal courts do permit these subrogation actions. And the court is correct, and that's detailed in the attorney's title case, which made the point that the federal courts do permit a subrogation action to be brought at the same time. Finally, I would point out that the language in 1.080, which was amended in 1984, I believe, specifically permits a third-party action to be brought by a party who is or may be liable to the plaintiff, and that is clearly the case here, just as it is in contribution and indemnity cases. If the court has no further questions, I'll rely on my brief. Thank you.
Okay, thank you. Well argued on both sides.